So how did the law of negligence develop? The tort of negligence. And what is the word tort? It's a French word meaning wrong. So to commit a tort is to do another person a wrong. But this is not a criminal wrong, it's a civil wrong. So there's no criminal penalty, but damages in compensation are payable. So the person who commits the tort is known as the tortfeasor, the one who makes the tort. And as I say, he is not punished with a criminal sentence, but may be required to pay compensation. We have a duty not to harm others, whether that is a physical harm, psychological, or a reputational harm. The first question to ask is, how does this duty arise? The duty arises because a person carrying out an act has a duty to do so with at least ordinary care and skill if other people might be affected. For example, the driver of a vehicle has a duty to all other road users to drive with ordinary care and skill, although this is phrased slightly differently in Section 2A of the Road Traffic Act 1988. There the requirement is to drive in a way expected of a, quote, competent and careful driver, which is basically skill, i.e. competent, and care, as in careful driver. So it's exactly the same thing, just phrased differently. Note that in being on a public highway, the driver owes the duty to all the world, that is to say, all the people who are using or who are going to use the highway at the same time as the driver will be using it. The law has a very useful term for a person, whether the driver of a vehicle or anyone else who does not carry out their duty of care and skill, and that is the term negligence. It used to be thought that a duty of care and skill could arise only if there was a contractual relationship between the tortfeasor and the injured person. But the case of Heaven v. Pender in the 1880s changed all of that. So in that particular case, a ship painter had used a staging around a ship which had been erected for the purpose of painting the ship's hull. One of the ropes which held the staging in place was defective. In fact, it had been burnt, causing the staging to fall and the ship's painter to be injured. The defendant contended that since he did not employ the painter, and since there was no privity of contract between him and the claimant, that therefore the claimant could not recover any damages. Having considered the duties which arise under contract to use ordinary care and skill, and also the analogous situation where one person invites another to his home and the guest is injured as a result of something done or not done by the host, the court formulated a new test in Heaven v. Pender. So Master of the Rolls, Brett M.R., said that whenever one person is by circumstances placed in such a position with regard to another, that anyone of ordinary sense who did think would at once recognise that if he did not use ordinary care and skill in his own conduct with regard to those circumstances, he would cause danger of injury to the person or property of the other. Then a duty arises to use ordinary care and skill to avoid such danger. So that case, Heaven v. Pender, is a key case in establishing that the duty of care is not confined to contract, but that any situation where one person is carrying out an action which could affect another, and that person, person A, let's call him, that person, person A, fails to use ordinary care and skill and thereby causes injury to a person who could reasonably be affected by person A's actions. Then if such injury occurs, person A will be liable to person B. Now it only applies if person A has been negligent. If person A took all reasonable care and circumstances were beyond his control and person B was injured, then there is no negligence and hence no duty of care. Now Heaven v. Pender was heard a long time before Donoghue v. Stevenson, and you will remember that in Donoghue v. Stevenson, Atkin LJ articulated for the first time the neighbour principle, and this is worth knowing. You must not injure your neighbour, and the lawyer's question, who is my neighbour, receives a restricted reply. You must take care, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who then, in law, is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. And that was Lord Atkin in Donoghue and Stevenson. And so I think it's safe to say from what we have been looking at here, that the modern law of negligence relies heavily on Donoghue v. Stevenson, and that Heaven v. Pender paved the way for Donoghue.